Welcome to this IAA session. My name is Ali Vaziri and I'm a lawyer at the law firm Lewis Silkin, based out of our London offices. I'm going to be talking to you in this session about the Age-Appropriate Design Code, known more commonly and colloquially as the Children's Code. And to save on syllables, that's how I'll refer to it today. The Children's Code was issued by the ICO, the UK's data protection regulator, and came into force last autumn. So far, there's been a 12-month transition period to allow businesses time to prepare, but that ends on the 2nd of September of this year. That's when enforcement can start. And the ICO is clear that if you don't conform with standards in the code, then you're likely to find it more difficult to demonstrate compliance. And since it's a statutory code of practice, in other words, it's not just guidance, it must be taken into account by the courts in legal proceedings and the Information Commissioner in any regulatory action. The code's theme of children is already very relevant in the UK. That's partly because the government is focused on introducing comprehensive legislation to regulate a range of online harms. But it's also because we have at least 2 class actions against social media platforms concerning the use of children's personal data, which are stayed pending the outcome of a decision of our Supreme Court heard last month. Our lack of imagination means that both of those cases follow on from FTC findings from your side of the Atlantic. Children are afforded special protection in the GDPR, and the use of children's data is a regulatory priority for the ICO, especially given the public interest in protecting children online. Code compliance also feeds into your brand's reputation and values, and marks a change of mindset. Indeed, change is coming, and not just in the UK. Other EU jurisdictions, such as Ireland and France, are also looking at the issue. So what's the code about? Well, it translates GDPR requirements into 15 standards for online services, and we'll look at those standards in a bit. But keep in mind that the aim of the code, as stated by the ICO, is not to protect children from the digital world, but instead to protect them within it by ensuring online services are better designed with children in mind. Who does the code apply to? Well, it applies to relevant information society services which are likely to be accessed by children. This definition breaks down into 3 elements. The first element is information society services, which is defined as any service normally provided for remuneration at a distance by electronic means and at the individual request of a recipient of services. Most online services will be caught by this definition, though there are some exclusions. Remuneration means for profit, but the remuneration doesn't need to be directly from the end user, so it includes where the service is free to users, but is, for example, funded by ads. The second element is children, who are defined as being under 18 years of age, a definition adopted from the UN Convention on the Rights of the Child. It's important not to confuse this with the age of consent to information society services in the UK, under Article 8 of the UK GDPR. That age of consent is 13 years old. Put another way, just because a child is old enough to consent doesn't mean they're no longer a child. The third element is likely to be accessed, and the test here is whether the possibility of children accessing your service is more probable than not. You'll need to consider the nature and content of the service and whether that has a particular appeal for children, and the way in which the service is accessed and any measures put in place to prevent children from gaining access. The key point here is that the code covers services that children use in reality and not just those specifically aimed at or targeting children. Finally, on territorial scope, note that the code doesn't just apply to UK-based companies. It also applies to non-UK companies who process the personal data of UK children. If you're within the scope of the code, you will need to apply its standards. And here's a list of all 15 of them. First and foremost are the best interests of the child. That's because the code incorporates the key principle from the UN Convention that the best interests of the child should be a primary consideration in all actions concerning children, including when designing and developing online services likely to be accessed by them. To assess and mitigate risks to children likely to access your services, data protection impact assessments, or DPIAs, must also be completed. Many viewers will be familiar with DPIAs, which are a key part of accountability obligations and taking a data protection by design approach. Offering online services directly to children is deemed by the ICO as likely to be high risk, and as such, a DPIA must be completed. In case it's useful, do note that the code provides a children's code specific DPIA template. The third standard, age-appropriate application, involves taking a risk-based approach to recognizing the age of individual users and ensuring you effectively apply the standards in the code to child users. You'll need to establish age with a level of certainty appropriate to the risks, or apply the code standards to all your users. It's one of the more challenging standards of the code, and the ICO recognizes it as such. Skimming through some of the other standards, settings must be high privacy by default, unless there's a compelling reason not to. Only the minimum amount of personal data should be collected and retained. Children's data should not usually be shared. Geolocation services should be switched off by default. Nudge techniques should not be used to encourage children to provide unnecessary personal data, weaken or turn off their privacy settings. The code also addresses other issues, such as those of parental control and profiling. There's certainly a lot to consider when it comes to children's code compliance. But before you panic, the ICO has said that it is not expecting full compliance by every company by the end of the transition period. It will take a risk-based approach, and the focus will be on the highest risk companies because of the severity of harm to children, or where a large number of children are adversely affected. Proportionality also means that businesses are expected to act responsibly within their resources and the available technology, as evident when, for example, it comes to determining and verifying the age of users. In terms of next steps, we'd recommend these three. First, check whether you're in scope, i.e., are your services likely to be accessed by children? Even if you believe you're out of scope, make sure that you have supporting evidence such as user testing and surveys, market research or academic literature, etc., in case you are later questioned. Secondly, start your DPIA. Remember that all businesses within the scope of the code need to complete one. The process will necessarily involve some mapping of children's data and age ranges, as well as the associated user journey. You will also need to look at the risks and impacts to children. And finally, put a roadmap in place. The ICO has said that it doesn't expect the impossible when the transition period ends. And just as the ICO takes a proportionate and risk-based approach to enforcement, so should you when it comes to compliance. If changes can't be completed by September, you'll need to demonstrate that you're taking children's code compliance seriously, and a detailed plan for transformation will certainly help in that regard. I hope you found this introductory session useful, and do let us know if we can assist with any of your data privacy compliance efforts, including when it comes to the use of children's data in your online services.